seated. Court is back in session. Are we ready to bring the jury in?
Yes, Your Honor.
Okay, let's go ahead and bring them in.
Next witness is going to be actually the plaintiff of the Hannity interview. We had an instruction prepared regarding that redaction. I've got my copy here.
I'll take your copies, fine.
Yeah, I have it in front of me. It should be this here. You're welcome. Please be seated. Welcome back, ladies and gentlemen. I hope you enjoyed your lunch. During the lunch hour, if your answer is yes to any of my questions, please raise your hand. During the lunch hour, did any of you have any discussions amongst yourselves or with anybody else about the case? No hands are being raised. Did any of you read or listen to any radio, television, or newspaper reports about the case? No hands are being raised. Did any of you use any type of an electronic device to go on the internet to do independent research about the case, people, places, things, or terminology? No hands are being raised. And finally, did any of you read or create any emails, text messages, Twitters, tweets, blogs, or social networking pages about the case? No hands are being raised. Thank you very much. Mr. De La Rianda?
Your Honor, at this time we would formally play the Hannity interview on July 18th, 2012. And I think there's a preliminary instruction, of course.
Yes. Ladies and gentlemen, at the direction of the court, certain portions of the defendant's interview with Sean Hannity on July 18th, 2012 have been excised or redacted based upon legal determinations made by the court. The parts excised or redacted are not relevant, and you are not to concern yourselves with why this occurred or with the content of any excised or redacted portions. You may proceed.
Thank you, Your Honor. This was, for the record, states Exhibit 180.
And tonight, in an interview that you will only see right here on Hannity, George Zimmerman, the man charged with second-degree murder of Trayvon Martin, breaks his silence. Now, earlier today, I traveled to Seminole County, Florida. Let's go back to the night of the shooting. Take us back to that night. You were going to the store. Let's start at the beginning.
I was going to Target to do my weekly grocery shopping. Sunday nights was the only nights, well, Sunday after we mentored the kids, we would always go grocery shopping and do our cooking for the week. So I wanted to go to Target, and I headed out, and that's the last time I've been home.
Since that, you never went back since that day. We all have heard the 911 call. On that 911 call, you had mentioned that there had been a number of break-ins in the neighborhood. Why were you a community watch person? How long were you involved in that, and why did you become a community watch person?
In August of 2011, there was a home invasion. A young lady was home with her 9-month-old baby, and they broke in her sliding glass door. She barricaded herself in the upstairs bedroom, and my wife was home by herself, and she saw the people that burglarized her run through our backyard with their belongings. And even though my wife wasn't certain what happened, that was enough to scare her, shake her up. And I promised her I would do what I could to keep her safe.
Your gun was legal. You had a legal weapon in the state of Florida.
Yes, sir.
Why did you feel the need to carry a gun? A lot of people maybe have a weapon inside their home, but you decided to carry yours. Why did you think it was necessary to have a weapon with you, and did you carry it at all times?
I carried it at all times except for when I went to work.
Yeah. A lot of this case legally has to do with stand your ground. You've heard a lot about it, and I was just curious, prior to this night, this incident, had you even heard stand your ground?
No, sir.
You'd never heard about it before?
No.
Wow. Now, it was very interesting, in the 911 call that everybody has heard, you said that all of a sudden you found somebody who looked suspicious, he may be on drugs. That was one of the earlier comments that you made in that 911 call. What made you think he was suspicious, and what made you think that he might be on drugs?
I felt he was suspicious because it was raining. He was in between houses, cutting in between houses, and he was walking very leisurely for the weather. It didn't look like he was a resident that went to check their mail and got caught in the rain and was hurrying back home. He didn't look like a fitness fanatic that would train in the rain. He just seemed like...
Weren't there overhangs, though? He was walking, he wasn't standing still? And he was walking closer to the house, which is back from the sidewalk?
Yes, sir.
Am I understanding that right?
The overhangs are just in front of the front doors.
Yeah. You said he started from almost the beginning in that 911 call. You said he came towards you, and he seemed to reach for something in his waistband. Did you think that was a gun?
I thought he was just trying to intimidate me.
To make you think that there's a gun?
A weapon.
Of some kind?
Possibly.
You said in that tape, something's wrong with him, he's checking me out, I don't know what his deal was. So it's almost from the very beginning, you felt, are you saying on that 911 tape that you felt threatened at that moment when you said that to the dispatch?
No, not particularly.
What did you mean with, I don't know what his deal is, he's checking me out?
The way he was coming back, and I was on the phone, but I was certain I could see him saying something to me, and his demeanor, his body language was confrontational.
Do you remember what it was that you said specifically on the tape? Yeah. You said, then we get to the issue where you said on the 911 call that he's running. You said that to the dispatch. Is there any chance in retrospect, as you look back on that night and what happened, trying to maybe get into the mindset, because we also have learned that Trayvon was speaking with his girlfriend supposedly at the time, that maybe he was afraid of you, didn't know who you were?
No.
You don't think that, why do you think that he was running that?
Well, maybe I said running, but he was more...
You said he's running.
Yes. It was like skipping and going away quickly, but he wasn't running out of fear.
You could tell the difference?
He wasn't running.
So he wasn't actually running?
No, sir.
Okay, because that's what you said to the dispatcher, you thought he was running. And let me ask you this. At that point, we can hear the unbuckling of the seatbelt, hear you opening the car door, and the dispatch asks you at that point, and this became a very key moment that everyone in the media focused on, and the dispatcher asked you, are you following him? And you said yes. Explain that.
I meant that I was going in the same direction as him, to keep an eye on him so that I could tell the police where he was going. I didn't mean that I was actually pursuing him.
So this moment where some had suggested you were out of breath on that tape, you yourself were not running.
No, sir.
And you, I think, made a statement to the police that it was the wind as you were getting out of the car and moving, and that was the sound we hear, not you out of breath?
Yes, sir.
And welcome back to Hannity. We continue now with more of my exclusive interview with George Zimmerman and his attorney, Mark O'Mara. What did you do from that moment forward? Because this is where we get into this minute gap in this case. You know, and what did you do from that minute forward when the dispatch said, we don't need you to follow him? What did you do next?
I walked across the sidewalk onto my street, Retreat View Circle, where I thought I would meet a police officer that I had called.
So you did not continue to follow him at that point?
No, sir.
All right, so you continue from there. You sounded at that moment on the tape, though, a little bit distracted. What was the distraction? That you were looking for him, or?
I wanted to make sure that, I believe they asked me for my address, and I wanted to be sure that nobody was lingering and could hear my address and then come back. And I was making sure that there wasn't anybody that was going to surprise me, and just trying to give them an accurate location.
Because they said, you know, can we meet you here at a certain location? You said, have them call me.
Yes.
Why did you want them at that point to call you?
I hadn't given them correct address. I gave them the clubhouse vicinity. However, I was walking through to my street, Retreat View Circle, and I was going to give them the actual street number and name.
How long was it, George, after that you saw Trayvon again? Because you said you stopped, that you did not continue pursuing him. When did you next see Trayvon Martin?
Less than 30 seconds.
Okay. Where exactly were you at that point? And how far away were you from your car at that moment?
I'd guess about 100 feet or more.
So you never went further than how far approximately from your car?
I'd estimate it to be approximately 100 feet.
So you never went further than that from the car?
No, sir.
Okay. And so at that point, Trayvon is, all of a sudden you turned around and there he was?
Yes, sir.
What happened next?
He asked me what my problem was.
Expletive problem.
Yes, sir. And I was wearing a rain jacket, and I put my cell phone in my jacket pocket as opposed to my jeans pocket where I normally keep it. And I immediately went to grab my phone to this time call 911 instead of the non-emergency. And when I reached into my pants pocket, because that's where I keep it out of habit, it wasn't there, and I was shocked. I looked up, and he punched me and broke my nose.
One shot.
Yes, sir.
So he said to you, you have expletive, you have a problem. Those were the exact words he used. You remember it?
Do you have a problem? What's your problem?
What's your problem? And you said to him, I don't have a problem.
Yes, sir.
You reached for your phone.
I reached for it as I was saying, no, I don't have a problem.
And at that point, you just got hit?
He was already within arm's length from me.
And was that the punch in the nose that broke your nose?
Yes, sir.
Right there, and you went immediately down to the ground?
I don't remember if I went immediately to the ground or if he pushed me to the ground, but I ended up on the ground.
What do you remember happened from there? Because there were police reports and descriptions that you gave, and that you were a little bit dazed, obviously. And at one point you said that you wanted to stop him from hitting your head on the cement.
Yes, sir.
Is that what you told the police?
Yes, sir.
Okay, so after that first hit, what happened next?
He started bashing my head into the concrete sidewalk. As soon as he broke my nose, I started yelling for help. Because I was disoriented. And he started slamming my head into the concrete.
Which is where the lacerations came from.
Yes, sir.
You said it was like your head was going to explode, was a comment that you had given to the police.
Yes, sir. He continued to punch me in the head.
How many times would you estimate that he punched you?
Several. More than a dozen.
And hitting you hard. At what moment did you, because you said you feared for your life, at what moment do you remember when you literally do you remember when you thought, I may die? Is that, because you said that you feared for your life. Do you remember the exact moment when you felt that?
In hindsight, I would say when he was slamming my head into the concrete and I thought I'd lose consciousness. I didn't know what would happen at that point.
And how close was the concrete to the grass? Because a big issue is also the grass stains that you had on your clothes. And you had made a statement to the police that you wanted to get to the grass. Was that to protect your head from getting banged into the cement again?
Yes, sir.
How close was that in proximity?
It butts up to the concrete.
And were you able to get to the grass?
Yes, sir.
And how did you do that?
I guess you could say shimmy. I mean, he was straddled on me with his full weight, and I would try and sit up and push myself down. And whenever I would sit up, that's when he would take the opportunity to slam my head back down and punch me in the head and continue to hit my nose.
Was he talking to you a lot during this fight, when he was beating you? Because you're saying he's beating you and pounding your head into the cement. Was he talking to you during that time?
Yes.
And he was saying?
Cursing, telling me to shut up, and then finally telling me he was going to kill me.
And he said those words. And he said it. When did he first see your gun?
After we were on the ground, I shimmied with him on top of me, and it made my jacket rise up. And he being on top of me saw it on my right side.
What happened after that?
I felt him take, he had, after he couldn't hit my head on the concrete anymore, he started to try to suffocate me. And I continued to push his hands off of my mouth and my nose, particularly because it was excruciating, having a broken nose and him putting his weight on it. And that's the point in time when he started telling me to shut up, shut up, shut up. And
why did he tell you to shut up?
I don't know.
We heard the screams on the one recording from the neighbor that was calling the police, and there's been some dispute whose voice that is. Was that your voice screaming, or was that Trayvon Martin's voice screaming?
That was my voice. Absolutely.
That was your voice?
Yes, sir.
And the police even said at one time they heard 14 screams. You were screaming that loud?
Yes, sir.
And you said to the police at one point that he put his hand over your mouth. Do you think that was to silence you from screaming?
Yes, sir. I believe he, from what the investigators told me, he knew that I was talking to the police, and I was yelling so that I believed that the police officer was there, and they just couldn't find me. So I was yelling in the hopes that they were in the vicinity and they would come when they heard me yelling.
Do you remember when you yourself reached for your weapon? Do you remember that moment?
Yes, sir.
Tell us about that.
At that point, I realized that it wasn't my gun, it wasn't his gun, it was the gun.
Did he say anything? Because you said he was talking a lot about the gun. Did he say he noticed the gun?
He said, "You're gonna die tonight," and took one hand off of my mouth, and I felt it going down my chest towards my belt and my holster, and that's when I didn't have any more time.
Do you think you acted more out of a conscious thought? I mean, I know these events happen very quickly. Do you remember consciously thinking, I've got to grab my gun? Or did you just do it? Was there a conscious thought that went through your head that you thought you were going to die and that you had to take this, you had to get your weapon and fire?
I'd love to give you an answer.
You don't know.
It just happened so quickly.
Mm-hmm. There was an eyewitness that was out from the very beginning that, in fact, did tell the police the night of the shooting that he saw Trayvon on top of you and did see the beating. There is no witness to the actual shooting itself. Right? Correct?
Besides myself.
Besides yourself.
Yes, sir.
When you think back, and there was one report, or a police report, that actually said you didn't know after you fired, you thought you missed?
Yeah, I didn't think I hit him, yes.
Yeah. So what happened immediately after the shooting then, George? I understand one guy came out, he said he had a flashlight, that he spoke to you, and you said to call your wife, tell her what happened, that I shot somebody. Do you remember that conversation?
The conversation I had with the gentleman, or?
Yeah.
Yes, sir.
You do remember that conversation. And he did talk about it, and what his suggestion is that you were very matter-of-fact about it. Do you remember what you said to him? Do you think you were in a state of shock? Did you know that when did you know that Trayvon had died?
When I went, probably about an hour after I got to the police station.
After the shooting, you saw that he was laying there and obviously injured. There was a moment where you realized that he was shot.
Like I said, he sat up and he said something to the effect of, "You got it," or "You got me." I assumed he meant, "Okay, you got the gun, I didn't get it, I'm not going to fight anymore." At which point, I got out from under him.
Is there anything you regret? Do you regret getting out of the car to follow Trayvon that night?
No, sir.
Do you regret that you had a gun that night?
No, sir.
Do you feel you wouldn't be here for this interview if you didn't have that gun?
No, sir.
You feel you would not be here?
I feel that it was all God's plan, and for me to second guess it or judge it.
Is there anything you might do differently in retrospect, now that time has passed a little bit?
No, sir.
You know, the detective said, that Detective Singleton said, he quoted you saying, "The bad guys always get away." You also said that in the 911 tape. Did you have a feeling that there were a lot of people that do get away with crimes? In other words, were you sort of predisposed in your mind in some way to think that criminals get away too often?
Not in general. I think in our neighborhood, there's geographic advantages for burglaries.
Do you have any idea, why do you think Trayvon would have confronted you the way he did? I made a comment on the air one day, and I got beaten up pretty bad for saying this could have all just been a terrible misunderstanding or a mistake. Do you think maybe, is there any possibility he thought you were after him and you thought he was after you, and there was some misunderstanding in any way?
I've wrestled with that for a long time, but I can't. One of my biggest issues through this ordeal has been the media conjecture, and I can't assume or make believe.
The one witness that you first met, the guy with the cell phone that I mentioned, asked about your demeanor right after the shooting. He was the first person, I guess, on the scene?
Yes, sir.
First person you saw. And he said that you looked like you had been, quote, butt-whooped, like you had had a fight, and that you were asking, call my wife, just tell my wife. But, he was acting like it was nothing. Is that how you were feeling at the time? Because you didn't find out, you said, till later that Trayvon had passed away.
No, I knew that I had discharged my firearm, and I was scared, nervous. I also thought the police were going to come and see me with a firearm and shoot me. I mean, I was terrified.
Did you look over at Trayvon? You obviously at some point recognized he had been shot, because you didn't know it in the beginning. Did you look over at him at any time and realize he was in really bad shape?
No, sir.
At no point. And how long was it between the time you shot him to the time the police actually got to the scene?
It felt like forever. I'd say 15 to 30 seconds.
It was that quick?
Yes, sir.
Immediate. So in other words, they had already been on their way, and they were there within 15 and 30 seconds. What do you make of all the national media attention in this case? There are crimes that happen every day. The nation is focused on your case. Why do you think that is, and what do you make of it? And what does it mean to you?
It's surreal. I don't like that they've rushed to judgment the way they have. I feel that anytime they have a story that's remotely positive, they interpret it negatively.
You had called police on at least 4 prior occasions and had mentioned black male suspects. I wanted to give you a chance to respond. Why you called? What were those instances about?
They also stated that, and I never volunteered that information. It was always at their request that I described them, and even when I described them, I didn't volunteer the race until they asked me. And there was also Hispanic kids and white kids that were in the
That you
neighborhood.
made calls about?
Yes, sir.
Let me ask you this. I want to go back to one specific in the case, if I can. And it's the issue of you following him. And I asked you earlier about the dispatch call, and you said you stopped. You didn't follow him. There's one moment that you were apparently, as you look at the grounds of where this took place, and there's the apartment, and there's the overhangs, and then there's another street on the other side, and you had gone to the other street, correct?
Yes, sir.
At some point. So how do you get to the other street if you're not following him? I mean, where were you going at that point?
I was walking from where I had parked my car towards my street. He went right down in between the houses. I walked straight across to.
But in that sense, were you following him?
No, sir.
You weren't following him?
No, sir.
And this is after the 911 call?
During
During the 911 call?
when they stated, we don't need you to do
So
that.
why were you walking back to your street and not back to the car
I was
at that point? If I'm trying to get the chronology right.
certainly where I parked my car was the back of townhouses. There wasn't a way to know what the street number was, and I knew if I walked straight through, it's a circle, Retreat View Circle. I knew if I walked straight through to there, that would be Retreat View Circle, and then I could tell them exactly what 1, 2, 3, 4 Retreat View Circle, and not just a general area of where my car was like I had done previously.
Call your next witness, please.
Dr. Valerie Rao.
Do you solemnly swear or affirm that your testimony in these proceedings will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
You may proceed.
Thank you, Your Honor. Good afternoon, ma'am. If you please tell the members of the jury your name
Yes, my name is Dr. Valerie Rao. My last name is spelled R-A-O.
and how are you employed?
I'm the District 4 Medical Examiner.
And what comprises District 4?
District 4, we have 3 counties, Duval, Clay, and Nassau.
And are you the chief medical examiner in your district?
Yes, I am.
How long have you been a medical examiner in total?
32 years.
And are you also a licensed physician and surgeon?
Yes,
And how long have you been so licensed in the state of Florida?
since 1981.
Can you summarize for the members of the jury, please, your educational and professional background?
Yes, I got my degree in medicine in 1971, after which I went to London. I spent a year and a half doing pathology at 2 hospitals, one St. Heliers Hospital in South London and the other St. Andrews Hospital in East London, after which I came to the US and I did residency, 5 years totally, 2 years doing clinical pathology at Berkshire Medical Center, Pittsfield, Massachusetts. 2 years doing anatomic pathology in Albany Medical Center, Albany, New York. 1 year doing forensic pathology in Baltimore for the state of Maryland. I'm board certified in anatomic, clinical, and forensic pathology. I then spent a year in Tucson, Arizona, where I did medical examiner work. Sorry. I was medical examiner for a year. 1 year as medical examiner. After which I went to Miami, where I was an associate medical examiner for a total of 19 years. I then took a chief position in District 5, where I was there for 3 years. I went to the University of Missouri in Columbia, where I was associate professor for 2 years, and then came to Jacksonville, where I've been here for about 7 years.
And just briefly, what are your duties as a medical examiner?
In the state of Florida, we're required to investigate sudden, unexpected, unnatural death, and ultimately to sign the death certificate, the cause and manner of death.
What is meant by the term pathology?
Pathology is the study of disease in the human body.
And what is meant by forensic pathology?
Okay, so in forensic pathology, it comes under the umbrella where the sudden, unexpected, unnatural death cases come under the forensic pathologist.
And have you ever been qualified as an expert in the courts of the state of Florida in the field of forensic pathology?
Yes.
Approximately how many times?
Hundreds of times.
Do you also have experience examining injuries to living people?
Yes.
And explain what that experience is.
Okay, so when I was in Miami, where I was an associate medical examiner, had the opportunity to work there at the Rape Treatment Center for 18 years, where I saw several thousand living patients, examination and treatment of these victims.
And what types of injuries would you see when examining those victims?
Okay, some of the patients that came were also physically assaulted. So there were injuries that come under the category of blunt force trauma. There were patients that were stabbed, so that's sharp force injury. Some of the patients were strangled but did not die. So we saw this gamut of cases in living patients.
And what are blunt force injuries?
So blunt force, the term is to distinguish it from sharp force, meaning that the instrument that's being used, for example, a bat would qualify as a blunt weapon. A stick, if I was to bump myself as I came in here on the corner of this table, I would suffer blunt injury if it was severe enough to cause injury. Whereas a sharp force is injury that is caused by a sharp weapon, a knife, a bottle that is broken and then the sharp edge used to inflict trauma. So this is the difference between sharp force and blunt force trauma.
Within blunt force trauma, are there different types of blunt force trauma?
Yes.
And what are those?
So the first part of it, let's look in progression of severity. A bruise, we're talking about a small bruise, is where the skin is intact and the blood vessels under the skin are injured and they bleed under the skin and get what you know as a bruise. The skin is intact. Then you have a scrape where the skin is compromised and it's, for example, a rug burn would qualify as an abrasion. Then you have the lacerations where not only the skin is torn, but the underlying tissue is also torn, exposed to the outside. And depending on the severity of the laceration, you will get varying degrees of bleeding and trauma.
All right. Are bruises also known as or referred to in your field as contusions?
Yes.
All right. And then scrapes is the same as a laceration?
Abrasion.
I'm sorry, abrasion.
Yes.
And then there's lacerations?
Yes,
Okay.
which is basically, laceration is a tearing of tissue.
All right. Have you ever been qualified in the courts of the state of Florida as an expert in the area of conducting rape examinations and all manner of injuries associated with rape victims?
Yes,
And again, approximately how many times?
hundreds of times.
During your tenure as the medical examiner in Miami, did you also examine other categories or sets of living victims?
Yes.
And explain what you mean by that.
So, for example, somebody alleging police brutality, the medical examiner, we just were housed directly across a very large hospital in Miami, Jackson Memorial Hospital. So the police would ask if we could go and examine to see if the allegations were actually borne out by the trauma. So we would go across the street, we would photograph, we would put out a report, and those reports come under consultations. Also child abuse cases, especially if the clinical people thought that the child was going to die, they would ask us to come and take the photographs and do the interpretation. So we basically practiced forensic medicine, not really forensic pathology, where you're only looking at dead people.
You know, at this time I would tender Dr. Rao as an expert in the area of pathology and forensic pathology.
I don't think that's necessary under the current case law in this state.
She'll be able to testify in those areas.
Thank you, Your Honor. Were you asked to examine some evidence in the state of Florida versus George Zimmerman?
Yes.
And specifically, what were you provided in regards to that case?
Okay. So I was given a whole series of things that I asked for the whatever is available, because I'd like to do the consult, having as much as possible in the database before I formulated an opinion. So what I received was a reenactment of the incident involving the fatal shooting. This was recorded on the 27th of February 2012. I got a set of 36 photographs taken of Mr. Zimmerman, documenting the clothing, the injuries, the medical records from the Altamont Family Practice Clinic. And of course, there were two records from this clinic. One was on the 27th of February, and the other one was on the 9th of March 2012. I got a DVD labeled Sanford PD Lobby and Others. It showed the vehicle going to the police department and Mr. Zimmerman being taken by the police into the department to be booked. A DVD labeled Medical Examiner Report and Photographs. And this included the medical examiner report, the body diagrams, the autopsy photographs. 26 autopsy photographs were taken, the toxicology report, and then a report that states two individuals were involved in a physical altercation in the yard, and one of them fired a handgun and the decedent fell to the ground. And the other items in the same folder were the medical examiner autopsy report, the toxicology report. So this is what I received.
Did you also receive two photographs of the defendant at the scene the night of the event?
Yes.
And when you said reenactment, when you referred to the reenactment, was that an interview where he conducted a walkthrough and led investigators through the scene and explained to them what happened?
Yes.
After reviewing all of those items, in terms of severity, how would you classify the injuries to the defendant's head?
They were not life-threatening. They were very insignificant. They did not require any sutures to be applied to Mr. Zimmerman. So, as I will refer to them, insignificant injuries.
Did you observe any lacerations to the back of the defendant's head?
Yes.
How many?
2.
And were those lacerations depicted in the photographs that you reviewed?
Yes. They were. There was bleeding, so I was not able to look at them after they were cleaned, because subsequently, when he went to the Altamont clinic, they were covered by Band-Aids.
And were you also provided the reports from the Altamont Family Springs Clinic describing the injuries as they were viewed by a physician's assistant the next morning?
Yes.
All right. Your Honor, would you assist me with the lights? Dr. Rao, let me show you first, State 79. Was that one of the photographs from the scene that you were provided?
Yes.
And State 76, was that a photograph from the scene you were provided?
Yes.
Let me show you States 57, where you also provided that photograph.
Yes.
All right. Your Honor, may I approach the witness? Yes, you may. Dr. Rao, let me give you this pointer. You just press that button. If you would explain for the members of the jury where the lacerations are located that you observed and that were referred to in the family clinic report.
Okay, so we have one small injury right there. and one injury right there, where the blood is streaming from. So these were the 2 lacerations.
All right. In the Altamont Family Clinic report, were you also provided with the measurements of each of those lacerations?
Yes.
And are either of those lacerations life-threatening?
No.
Why not?
Because they were so minor that the individual who examined and treated Mr. Zimmerman told him that the sutures were not required. So she put a Band-Aid on each of them, and that was the extent of the treatment.
All right. Are there also some contusions or a contusion on the back of the defendant's head?
Yes,
And can you show the members of the jury where that is in the photograph?
right there.
And is that a life-threatening injury?
No.
Why not?
Well, the reason I asked for everything was I then looked at the entire case file, and when he walked from the police car to the police department to be booked, he was not incapacitated in any way. He was very alert and walking, in pace with the officers.
Are the injuries that you observed to the back of the defendant's head consistent with his head having made contact with a concrete surface?
Yes.
And why do you say that?
So, I've looked at the other areas that were photographed, and they have a sort of a pattern that were punctate, meaning that there were little areas which came into contact with a rough surface. But so looking at the concrete area, again, the reenactment that I was given, it's consistent with his head having come into contact with that rough surface.
And are the injuries on the back of the defendant's head consistent with one strike against a concrete surface?
Yes.
And why do you say that?
Because if you hit the head one time, it is consistent with having gotten those 2 injuries at that one time. Because it's an area where it is protruding, because the head is protruding, because the head is a round surface, and so that one impact could result in the 2 lacerations that you see.
And are the injuries you observed to the back of the defendant's head consistent with his head having been slammed repeatedly into a concrete surface?
Okay, so I'm going to give you my what I think based on the dictionary definition of slammed is. And there are 2 definitions from 2 different dictionaries.
Let me object, Your Honor. If she's going to define a word from a dictionary, that would be hearsay.
Please approach.
May I proceed? Yes, ma'am. Dr. Rao, using your definition of slamming, your common understanding of slamming, are the injuries to the back of the defendant's head consistent with having been repeatedly slammed into a concrete surface?
No.
Why not?
Because if you look at the injuries, they are so minor that, to me, the word slam implies great force. And the resultant injuries are not great force.
What type and extent of injuries would you expect to see if the defendant's head had been repeatedly slammed into a concrete surface?
So if somebody's head is repeatedly slammed against concrete with great force, I would expect lacerations. I would expect a lot of injury that would bleed profusely, that would necessitate suturing, and so I don't see that in this picture.
All right, let me turn your attention to States 47. Were you also provided that photograph?
Yes.
And what injuries did you observe in this photograph, States 47? If you would, just describe those for the jury.
Okay, so there is a small abrasion on the bridge of the nose right there. It's a very small little punctate at the tip of the nose.
Can you circle that with your laser, if you would,
Yes.
or just indicate it?
Right there
Okay.
and right there.
And are any injuries in this photograph life-threatening?
No.
Why not?
He has no loss of consciousness whatsoever. He didn't have to go to the hospital. He went to a clinic.
Were there any contusions or abrasions that you noted in this photograph?
Yes,
All right, can you again show us where those are?
yes. Right there and right there.
How would you characterize or classify the contusions, the severity of the contusions or abrasions to his face?
Very small.
Could all of the injuries that you observe in that photograph have come from a single punch or a single blow?
Yes.
And why do you say that?
Okay, so if you look at the distribution of where the injury is, and let's think that I'm the one inflicting the blow. If I was to punch myself right above here, I would get the injury on the nose and on the few contusions on the forehead. So one blow would be able to inflict these injuries.
Are the injuries that you observed to the defendant's face consistent with the defendant having been beaten a dozen times or more in the face?
If he was beaten repeatedly but with no resulting trauma on the face, then yes. But if the force is such that you get trauma, then only one time.
Did you observe contusions to both sides of the defendant's head?
On the sides, yes. Yes.
All right, let me show you State 75. Was that a photograph you were provided?
Yes.
And could you circle the area of contusion that you observed in State 75?
Okay. So one has to disregard this dried blood because it is coming from the laceration on the back of the head that I had demonstrated earlier. So we are looking at a contusion here, and there are very, very fine punctate abrasions that you need to have a close-up photograph to really see them.
And again, explain for the jury or define for the jury what's a punctate abrasion.
Okay, punctate means like a little speck, like a spot.
All right. Are any of the injuries depicted in State 75 life-threatening?
No.
And in terms of severity, how would you classify the contusions or abrasions in this photograph?
They are very small injuries.
Could all the injuries exhibited in State 75 have come from a single blow?
Yes, one impact against concrete, yes.
Let me show you State 73. Was that also a photograph you were provided?
Yes.
And what injuries are depicted in State 73?
Okay, so here again you have to disregard the dried blood that's coming from the laceration to the back of the head. And so you can see very, very faint, again, punctate, small abrasions.
Are any of those abrasions life-threatening?
No.
And how would you classify the abrasions depicted in State 73?
Very insignificant.
Could those abrasions depicted in that photograph have come from a single blow?
Single impact, yes.
All right. And why do you say that?
Because the surface area on the side, if you look at my head, and I was to get on the concrete, I could get all those injuries from one impact.
You also mentioned that you viewed video clips of the defendant getting out of a police car and walking through the police station that evening. What did his appearance in that video demonstrate to you regarding his injuries?
Oh, He was not incapacitated in any way. He walked on his own power, and he was also conversing with the police officers during this reenactment.
All right. Thank you, Doctor. Judge, that's all I have.
Okay, thank you, Cross.
Yes, thank you, Your Honor. Good afternoon, ma'am.
Good afternoon.
You got your appointment to your present position because Ms. Corey, the prosecutor in this case, appointed you, correct?
Correct.
Okay, so she's sort of your boss?
Not really, no.
But it was because of her. I mean, she appointed you to this position, right?
She actually sent my name up to the governor. So if you want to call that an appointment, well, then so be it.
Well, why don't we do this? I'm going to read a letter to you. Tell me if you consider this appointment. Pursuant to section 406.15, I hereby appoint... I'll approach and let her review it, maybe? I just have it electronically.
It's okay. I could explain.
Okay,
if I
so
could,
let me
if I could.
ask the question.
Okay.
Is what I'm looking at a letter signed by Ms. Corey where she says that she appoints you to that position, yes or no?
That was the interim position. I can't say yes or no because I have to explain to you.
Well, I'll tell you what, I'll walk you through it.
One at a time.
I'll walk you through it, okay?
Okay.
There was a yes to that. She appointed you to the interim position?
Yes.
And you had another position as a medical examiner in the state of Florida too, correct?
Yes.
That was with the 5th District?
Yes.
But you were not reappointed to that position by the governor, were you?
I did not seek reappointment. It
Okay,
was
that was
tabled.
because, I'm sorry?
It was tabled. I did not seek reappointment.
And that was because of some of the problems that existed in your administration in that office, was it not?
Correct.
Okay. Yeah, you got the job with Ms. Corey's office, or actually in the same district where she prosecutes, correct?
She's a state, yes, yes.
How much of your work is on behalf of the state attorney's office in that district?
Well, the medical examiner really does not work for the state attorney. We are separate, but most of the time we are called by the state. However, the defense can call us. You could call me on this particular trial, and I would be here for you, just like I'm here for the prosecution.
Fully get that. My question was how much of your work is on behalf of the state attorney's office in Duval County?
All the homicides.
Okay. All the work, right? You only deal with homicides, right?
No, we do suicides, we do traffic accidents, we do drug overdoses, we do natural death where there is no physician to sign the death certificate. So it's other work. Homicides are a very small percentage of our cases.
I'm sorry, then let me clear it up. How much of the work that you do involve crime matters? And I'm presuming in that question that all of your crime matters are dealing with the Duval County State Attorney's Office. So how much of what you do is related to criminal activities?
Okay, so we have a total of 1,165 cases, autopsies.
Okay.
And out of that, we are probably 110 homicides. So that is the proportion.
Okay. And in all of that work, you work with these very prosecutors, correct?
That is correct.
I mean, these are the homicide prosecutors for that division or that office, right?
Well, we have a whole series of state attorneys, yes.
Okay.
But they are in that office.
So they called you to look at this, correct?
Correct?
Did they have you look at anything having to do with Trayvon Martin?
No.
None
well, they sent me the autopsy report, so I saw that, yes.
But you're not here to tell us anything about
No.
Trayvon Martin. You're just talking about George Zimmerman.
That is correct.
And if I get it right, it's your position that's at least consistent that George Zimmerman may have only received as little as 3, did you call, what term did you use, smashing? Or
Sorry?
what, slamming. 3 slamming into cement, correct?
I didn't use the word slamming.
I'm sorry, I thought it was your word.
No, I got that from the reenactment.
What word would you use to describe what happened to the head that you say hit cement?
Impact.
Impact. So it's your position that there are at least 3 impacts between that head and cement.
Yes.
Okay,
Concrete.
concrete. However, and you said it's sort of consistent, so I'm going to walk you through some of that. I'm not going to use pictures right now. Let's just chat a little bit about it, okay? I think you used a suggestion that if you hit yourself in the nose that it could be all one shot, correct?
One blow. Correct.
Okay. You're not certainly just suggesting that it was only one blow, correct?
No, but
Okay.
consistent with.
And you say consistent with to minimize the number of shots that it could possibly be, correct?
Not minimize, but if you gave me another scenario, I could look at that scenario
Let me give
and
you-
see if it's consistent.
Let me give you this scenario. He gets hit in the nose like this, just like that, but it does not go up here. So here's the first shot, and here's the second shot. How many is that?
2,
Consistent with that picture?
it could be, yes.
Is it any more consistent or any less consistent than the fact that there was one shot?
I'm sorry, I didn't get that.
I'm sorry. You said earlier that those injuries could be consistent with one shot.
Correct.
And now I think you may have said it could be consistent with 2 shots.
If the way it's depicted, like you have depicted, yes.
Well, you don't, just so we're clear, you don't know how Mrs. Zimmerman was hit by Mr. Martin, correct?
Correct.
So you're saying it's consistent with 1, potentially, yes?
Yes.
And it also is consistent with 2, correct?
If the way it was portrayed, yes.
Which you don't know.
Correct.
So could you just say, is it consistent with 2 as well?
It could be, yes.
Okay, and it could be consistent with 1.
Yes.
Okay, and it actually could be consistent with another couple of hits with a palm, or as you said, another couple of hits with a fist that just didn't leave visible injuries.
Yes.
So you're certainly not telling this jury that Trayvon Martin only hit Mr. Zimmerman in the face 1 time.
I'm just telling you what the injuries are and what it's consistent with.
Okay. Did you notice in those pictures the cuts on Mr. Martin's knuckle on his left hand, both on the ring finger and a slight one on the pinky?
Okay, those are not cuts, those are abrasions. So, because cut suggests sharp force injury, and they are actually where the skin is rubbed off on Trayvon Martin's hand, correct?
That was a yes? You did notice them?
Yes,
Okay. Are those consistent with striking somebody?
yes,
So we have some injuries, the only injuries, as a matter of fact, besides the gunshot wound, are 2 injuries on his knuckles, correct?
correct.
Curious, since you've had a chance to look at the autopsy, were there any other injuries on Trayvon Martin at all?
No,
Any bruising injury?
no,
Any laceration injuries?
no,
Any punctate injuries?
no,
So you know for a fact that Trayvon Martin's head or any part of his body was not in contact with cement, correct?
well, I didn't see any injuries. You can have a contact, but without producing trauma that's visible, so,
As Mr. Zimmerman could have, correct?
correct.
A dozen of them even, right?
Sorry?
A dozen even, correct?
A dozen what?
Other impacts. Well, let's get more specific. We've now talked about the potential of 2, you would even admit, let me ask you this. Is there a possibility that with a swat or a hit or a fingernail or something, that even this abrasion on his nose could have been a 3rd?
Anything is possible.
Well, you're here as an expert,
Yes.
so I want you to give us your opinion. Is that possible based upon your level of knowledge?
Okay, so I will ask this. I know I'm not supposed to ask you questions,
Go
but
ahead.
you know. So then the next issue would be that each of the punctate marks on his head could have been caused by, you know, a fingernail scratch, or I mean that would be the next question posed. And we're looking at the preponderance of the evidence and the opinion rendered thereby. So, you know, we can continue this.
Let's move on. Let's move on.
Yes. Okay.
But we'll spend a moment on the nose. So you saw on Mrs. Zimmerman's right side there was a protrusion to his nose, correct?
What does that mean? I don't know. I don't know
I'm
what
using the
protrusion-
word protrusion. It was the first photograph. Let's go back and see if we can take a quick look at this. You see, you have, no, we both have one. You have a pointer, correct?
Yes, I do.
You see that spot right there?
That's the abrasion, yes.
No, right below, that little swelling spot right there. Do you see that?
I don't see a spot, but I see swelling, yes.
Swelling, I'm sorry.
Yes.
That swelling to an uninitiated view actually looks like there's a bone over there, doesn't it? But we know it's not, correct?
There is a bone, yes.
Well, but the swelling is not movement of bone, is it? or is it?
I don't follow that, I'm
Let me
sorry.
just ask you to explain then. What is that swelling on the right side of the nose from?
Okay, so that's trauma, injury.
Okay. And what happens is the body reacts to it by rushing lymph fluid to it and all this other stuff. It sort of tries to take care of the site of injury or trauma.
Yes.
And that recedes pretty quickly, doesn't it?
Oh, it depends on the extent of trauma, yes.
Well, and we know in this case, you acknowledge the trauma and the swelling there, right?
Yes,
And you notice in the pictures after it that the swelling has receded, correct?
yes.
So it does recede after a few hours?
Depending on the severity. Here it was not severe, so the swelling rapidly declined.
And you know that there was blood coming out of the nose as he was standing up, correct?
Correct.
Where do you think that that was bleeding from?
From inside his nose.
And where would that go if he's laying on his back?
Where would what go? I'm sorry.
The blood?
Well, it depends. If you are alive, you would, if it went back in your throat, you would cough it out.
Or swallow it?
Well, I don't know.
Well, I mean, it's going back down your throat, isn't it?
Yeah, you'd cough it out. I don't know if you would swallow it, but maybe that's a good suggestion.
Okay. So we have the nose injury, one. We have the potential of the injury up here that you identified could be a second shot, correct?
It's possible, yes.
Well, I mean, if I showed you a picture, let's just say that we did, in fact, have a video. And the video showed a smash to the head, to the nose here, and then sort of an overhand. Let's say that it was an overhand shot. You had a video, or let's say an eyewitness, who saw an overhand shot. Would that be consistent, the overhand shot, with that injury up there?
Oh, the small bruise?
Yeah, right up there.
It's possible, yeah.
Well, is it consistent?
It could be.
Okay. On the back here, you testified that you believe that all this was created or consistent to have been created with just one strike on the concrete or cement?
Okay, so all this, I don't follow that. I see 2 lacerations and a small bruise.
Okay, you see this laceration?
Yeah,
You
but
see this laceration?
okay, so, it's being actually camouflaged by the dried blood and the dripping of the blood, but once cleaned, the nurse that examined him said one was 0.5 centimeters and the other one was 2.0 centimeters, which is very small. And so, after it's cleaned and you look at the photographs, you don't see what your suggestion may be that there are a whole series of injuries back there.
All right, well, I'm just going to ask a couple of questions about all this. You said, I think, in direct examination that this is consistent with one strike upon cement, correct?
Concrete, correct.
Concrete. Now, you're not suggesting to some reasonable degree of medical certainty that there was only one strike here, correct?
No.
So this could, according to where this was, let's identify a term. I'm going to use the term crown, and we know the crown of the head normally is up here.
Correct.
But I'm going to use crown in a different term for the next few questions, okay? And that means the point that hits the cement. Can we use that term for just a couple of questions? Do you know what I mean by that?
Do I do what? Sorry.
Rather than the crown, which would be the first thing to hit the ceiling if you stand straight up, I'm going to say that, let's just say that this is where the impact on the cement is, okay?
Okay.
Now, the head could impact just there, correct? And just hit there, right?
Well, if the impact is on the side.
Absolutely, because we don't actually know what part of his head contacted the cement, do we?
We know that there are 2 injuries that resulted from the impact.
Right.
That's a given, right?
And they could be separate, right?
Except that it's in close proximity, yes.
Right. So I could hit a knuckle right there, or I could hit 2 knuckles at a time, correct? So it's according to how it happens, right? What the physics is of how it happens?
I'm not very good in physics, but we're not
sorry?
talking about knuckles, we are talking about one surface area. So I can explain just simply, I don't know about what the physics of this injury is.
Then let's get away from physics and talk this way. Let's just say that he was hit where, see this line right here? See that line? Do you see me making a line?
You mean the area?
No. The line I'm making with the laser.
Okay.
Okay. Let's just say that only that on this side came in contact with the cement. Is that possible?
Oh, yes,
Okay.
it's possible.
And if that were true, that only the point on this side came in contact with the cement, that only that injury would occur, or could occur that way, correct?
It's possible.
And now, if we look at the other side, the same line, that side, let's just say that only this side of the skull was in contact with the cement, then that injury would happen, correct?
That's possible too.
Two separate injuries, correct?
It's possible, yes.
You're not suggesting it's any more likely one or two, are you?
So we are doing the preponderance of the evidence, and the preponderance would suggest that one impact is more plausible than the way the head is shaped to have two separate impacts. But if you say that that was something that was eyewitnessed, then yes.
Well, what if somebody put their hand, let's say, on the side of a skull and smashed this way? Would that?
Fact's not in evidence.
I'm sorry, Your Honor? I didn't hear the
The
objection.
fact's not an evidence sustained.
Well, let's just say that you have evidence that there is a fist getting hit down on one side of the head. Would you agree that the opposite side of the head would be forced downward?
It could.
Okay, so it could, right?
It could.
All right. And then that would cause an injury just on one side of the skull, correct?
It could.
And you see this bruising right here, do you not? See that swelling?
No, that's the shape of his head, I think.
So in your opinion, you've come to a medical conclusion that that crowning over there is natural?
Yes, that is the parietal area of the scalp, yes.
I'm curious why it doesn't seem to show itself as protruded on this side.
And sometimes the shapes of heads are different, we're not all symmetrical. And if you look, there is no discoloration there. So that may be an anatomic variation.
So right here, do you see any bruising or any discoloration at all in that photograph?
Okay, I don't see bruising, but I see small, very tiny punctate marks. And the other thing is, the photograph you're looking at, the hair is so short that if there was something there, we would be able to see it really well. And I have to strain to look and to see what you are suggesting. So I can't answer that question.
I just want to be clear because the jury will have not even these photographs, but they will have much better photographs to view and to study. But as I do that, I want to point out to you to see if we can focus you. Is it your testimony that this coloring here, this darkening in this way, is a natural occurrence on his skull and not evidence of a bruising? Yes or no?
I don't see a bruise there, but I did see, because I also have very good photographs, which you can see clearer, there are very fine punctate abrasions.
Okay. Let's speak a moment for what you do see then, the punctate bruising.
Not bruising, abrasions.
Punctate abrasions, I'm sorry. Is that the abrasions that you see over here?
Well, again, the photograph is so poor that, I have to look at my own photographs.
Then let's take a moment.
Okay.
Can I have some lights here on it? And I'm going to leave this up because it would be easiest for the jury, but let's coordinate. We might doctor the photographs you did look at and these photographs. May I approach the witness? Are you reviewing the photographs that you had?
Okay, so I will show you my pictures that I have. I printed them from the computer. So this is the one side. And this is the, I think the photograph that you're showing, and you can see very fine little abrasions there.
Well, let's identify that you're now looking at a copy of what is State's Exhibit 73. And I think we're going to have to do this a bit more formal. So if I have a moment, Your Honor, I'm just going to have to get the actual 8x10s out of evidence. What I'm going to try and do, Doctor, is to identify your photographs and connect them to the exhibits in. Did you get an entire picture packet from the State Attorney's Office to review?
No, I got a disc, and I printed out some of them because it was taking me so long on the computer, so I just printed a few of them.
Then we'll do it this way in case you don't have them all. May I examine her from this location because I've got exhibits that we do not have on.
Is the jury able to see in here? Yes, you may do so.
Let me show you what's in as State's Exhibit 69. Your Honor, these are in already, so I'm just going to identify them for the jury and have her testify from it. And let me ask you if you can look, first of all, let's identify, this is in fact State's Exhibit 69?
Yes.
Okay.
Yes.
You want to hold it for a second? Thank you. And I'm going to question you about that if you look at the photograph. Is it your testimony that in Exhibit 69 there is no bruising above Mr. Zimmerman's left ear?
I just see the punctate abrasions. I don't see bruising. And there are some marks on the head which are nevi, which are moles, brown moles. So you are seeing that also like there and there.
So, to point out, 2 inches above his left ear, this area of lightening and darkening you do not perceive as swelling?
No, I don't think that's swelling. I just think that's the shape of the head, but it's a very, very funny angle. And so there's distortion in that photograph, and I cannot tell you that that's bruising. I'm sorry.
Okay. And similar in States 57, so we're clear for the jury. In 57, sort of a back view, I asked you to focus first at the area we just looked at, which is about 2 inches above Mrs. Zimmerman's left ear. Are you suggesting that, again, that is not any type of swelling or bruising, but rather just the natural contour of his head?
Okay, so if you are suggesting that that's a swelling, then the bruise should be so marked that I should not have trouble looking and identifying that as a bruise. So I can't comment on that.
Is that a yes or a no? Do you say that that is bruising or not?
No,
Just above?
No, I can't see the bruise there. If that's what this part is what you're talking about, yeah, I can't say that.
Let me show you State's Exhibit 70 that's in evidence, which is a picture of the right side of Mr. Zimmerman's scalp, correct?
Correct.
And pointing your attention to the laceration, bruising, cut, use your term, not mine, just in the middle of that picture.
Yes, he has a bruise on the right side, plus he has the punctate abrasions.
Okay.
Yes.
The bruise on the right side, how do you think how did that occur?
Impact against concrete could give you that, and the other abrasions.
Now on number 70, let's look further back about 2 inches towards the back of his skull and tell me what you see there.
Okay. Are you referring to the small?
Yes, I am.
Okay, that is a small bruise. It's pink, discolored.
And is it your testimony how did that occur?
Impact could give you that.
And could that have been a different impact?
It's possible, yes.
It is possible,
It's
correct?
consistent, yes.
Matter of fact, how much of a distance do you think there are between those 2 points of impact?
Well, I think it's not just the distance, but also one has to look at the curvature of the head when you are, and when I'm giving you an opinion, I'm not only looking at the distance between the 2 contusions, but I'm also looking at the contour of the head.
That's what I was curious about, so let's talk about that. The contour of the head is somewhat sphere-like, is it not?
Oval, yes.
Oval. So if you have 2 points on a sphere or an oval, correct?
Correct?
It's convex, is it not, the skull?
Yes.
So if you have 2 points 2 inches apart, why is there not a continuous bruise or a scarring all the way across? Why would you have 2 separate ones?
Okay, so it's not scarring. Scarring is a different terminology.
I apologize for the misuse of the term. Why is it not one long, if it came from one contact, why is there not one long injury?
Okay, because the force applied to one area because of the contour may not be equivalent to the force in the other area, and so in one site the force may be sufficient to cause a contusion, but it's not. We're not like computers. It's not. You do something and you expect this result. We are dealing with a different configuration of the head, so. I don't think that follows. It's a nice thing to be able to say, but I can't say that.
Okay. Certainly it could have been 2 separate injuries, correct?
It's possible, yes.
Okay. And looking at States 69, I want you to pay some attention to what seems to be a view of the Mrs. Zimmerman's skull, correct?
Scalp, yes.
Scalp. That's right. His skull will be underneath, right?
Correct.
And I want you to pay attention to the top of the picture and see if you can tell us what you believe that protrusion to be, my term, not yours.
Okay, so on the other side, we are actually looking at a photograph of the left side of the head and the top of the head, and we actually are getting a view on the right side of that bruise that we talked about. So that's the same bruise.
Do you see the swelling is my question.
Yes.
Okay. So there's swelling, and you're suggesting, I would like you to be clear about this for the jury's consideration, that in exhibit number 69, you do acknowledge swelling that seems to be to the right side of the midline of the scalp, correct?
Correct. But you got the bruise, which, if you want to say, well, this is a swelling, but there is no bruising there. And if the swelling was so severe that you are looking at on the left side, then we would have a significant bruise, and we don't see that. Whereas there, it's a small bruise, but you can see the swelling. So you can't separate one from the other. So it's together.
Look at number 70, which we've talked about already, and tell the jury which bruise you believe that swelling is connected to.
I think it's that one. Because
I just want to be clear, you're thinking to the one that is behind the ear. You pointed to the one that is 2 inches or so behind the line of the ear.
I think because that's such a distorted photograph because we are able to see very well the right side. So why are we looking at a photograph of the left side and trying to draw that conclusion? I think that's extremely unscientific.
And I apologize for that, but I just want to be clear about one thing. It is your testimony here today that the swelling that's on the 69 on the right side of the midline of the scalp, that is the bruising that is the same bruising as exists with what you've identified now as the bruising behind the ear line on States 70, correct?
It could be, but like I said, it's very difficult for me to, to give an opinion on the photograph, which is so distorted.
Got it. Could it be a completely separate bruise?
Which one is
This
that?
one, the one on 69.
Well, if it was, why are we not able to see it from the right side?
Let's take a look at 71 then,
Okay.
and see what you see on that photograph.
Okay, so this is again the punctate abrasions that I talked about, and that is the bruise that we have to overlap. I think that's the
And let me
photo.
show you just at the very top of the crown of the head there, almost out of the top of the picture. Is that not the bruise that we see, or the swelling that we see on 69?
I find it difficult when half the photograph is cut to give an opinion. I would like to see what the injury is before I tell you that that's the injury. So why are we looking at distortion and half photographs when we have the full side to be able to look at and to render an opinion?
Well, I certainly only want to do and have you give us as good an opinion as you can. Do you have a photograph that better shows the injuries that we've now seen by looking at 69, which shows the swelling that seems apparent?
No, I have the same, but I have just copies.
Okay, but that doesn't show the swelling, does it?
They're the same photographs, so how can they not show? Okay, so they are the same photographs, so how can it be different?
I'm asking you, as you're here today, to tell me what picture you have of the right side of his scalp that shows or doesn't show the swelling that was apparent in State's Exhibit 69.
Okay, so I have the same photographs you have, except mine is, like I said, copies. So this is the photograph that you are describing?
I'm trying to find the one that's in evidence for that, if I might have a moment, Your Honor. Let me ask you to compare, if you would, the picture that you were just showing with State's Exhibit, I'm sorry, let me identify it, 70. Do you have that one?
I'm looking. Oh, no, I don't.
We have this back here. Thank you. So, the least number of contacts between scalp and cement were 3, correct?
Correct.
And as many as how many?
That's a scenario that you posed, so you would know how many.
Well, if you were to look at this from a medical perspective and try and come up with not the minimum number, but the maximum number, give us your opinion.
I told you 3?
That's the minimum, correct?
Correct.
My question is, tell us, in your professional opinion, how many it could have been as a maximum.
I don't know.
Why not?
Because you were presenting the scenario about various possibilities, so you have to tell me, and I will tell you yes or no.
Well, as I said to you, there could be a possibility that those 2 bruises were 2 different ones, correct?
On the head, yes.
2 bruises on the right side of the scalp.
Correct.
Okay, so I want you to include that. We also talked about the possibility that the 2 lacerations could be two different hits, correct?
Correct?
So I want you to include that. What other, and we talked about the nose and the forehead being two separate ones, correct?
Correct?
Okay, so keep going. How many other of those bruises could have occurred? Let's talk about the left side of the scalp. It has been your testimony that it is consistent with just the least amount of one strike on the cement could have caused everything on the left side, correct?
Correct?
How many could it have been more than that?
I don't know. You have to give me a scenario and we will say consistent or not.
Okay, you got hit 6 times on the left side of the skull. Consistent?
No.
Why not?
Because the injuries are so minor and they are patterned to some extent. So that would be beyond the realm, I think, of possibility.
4 hits on the left?
Well, if somebody is an eyewitness and says 4 times that this injury occurred, then of course that's the best estimate. So,
Okay.
you know.
Okay, so let's talk about 4 on the left side. You agree that would be consistent with the medical evidence, correct?
If it was witnessed, yes.
No.
But you can't just say 4 times and you're not seeing the injuries to match the 4 impacts slamming.
Listen to
Slamming.
my question.
Okay.
Is there any medical evidence that would exclude the possibility that skull was hit on the left side 4 times?
That's not my opinion, but it could be. It's possible.
Okay. Nothing to exclude it.
Nothing, sorry?
Nothing to exclude that as a possibility.
It's possible.
Okay. Now on the right side, the side where we see the 2 separate bruisings, we talked about that, right?
Yes.
Could that, and we also see the punctate bruising in front, correct?
Abrasions.
Abrasions.
Correct.
Anything that would medically exclude that the right side was hit 4 times?
It's possible.
Okay. We see 2 of the bruises, right? And they could be separate, right?
Possible.
Then we see
yes.
the punctate abrasions. That could be another one, right?
It's possible.
Then we see the swelling that you say may be connected with one of the bruises, but that could be separate, correct?
I don't think so, because underlying the bruise you have the swelling. It's so impossible to get a bruise and a swelling and say, well, that was 2 different sites. Now the swelling is separate from the bruise, yes, but they are one injury.
Okay. Presuming that the bruising on States Exhibit 69 and 70, that the bruising that we see matches up in the jury's mind with that point of swelling, correct? You're making the premise.
It does.
Okay. In your opinion?
Well, you can see it.
Okay. And the jury will, of course, make that determination, right?
Correct.
Okay. And then there could be how many maximum times could the back of the head have been hit on the cement?
Well, to me, it was consistent with 1, but you suggested by turning the head in different ways, it could be 2. It's possible.
3 or 4?
With no injury, yes. If the head is in contact, producing no injury, yes.
How about the swelling below the lacerations? Did
The
you notice
contusion.
that?
The contusion.
Below, right.
The contusion, yes.
Could that have been a separate injury?
No, it's possible.
Well, if the head was hit so that just the crown hit the cement 1 time, let's say his head just snapped back and it hit here, that could have caused one of the lacerations, correct?
Yes, but it's
Okay.
so close to each other.
I-
That's the proximity that really kind of makes it possible.
Okay, I appreciate that. So if the head was tilted one way and then smacked back so that this was the crowning point, that would be 1 laceration injury, correct?
It's possible.
And then if the head was this way, another laceration injury, correct?
It's possible.
And then if I was able to resist one of the tossbacks of my head, I can actually keep the crown higher, and that back bruising that you just identified could have occurred, right?
It's unusual because, you're talking about a flat surface. So the head will have to be really contorted to be able to give you all those injuries from different impacts.
Change it now that it's not the cement, okay? Change it that it's here. Change it that what was hitting, that the bruise on the bottom wasn't flat, that it was against the side. Would that cause the bruising down here without the lacerations? Yes or no?
The side of what?
Side of the cement. You know that it was a cement sidewalk, correct?
Yes,
And you know that they were at the very edge of it, correct?
yes.
So you know that there is, in fact, an edge of cement, correct?
It's possible.
I'm sorry?
The injury is possible, like you are suggesting, yes.
Well, here's the cement, and we've been talking and discussing as though all the injuries are on the flat surface, right?
Correct.
So let's introduce now that there could have been some injuries here.
Your Honor, object to that as facts, not in evidence.
Hypothetical with an expert overruled.
It's possible.
Okay, so the possibility is that the head being hit against the cement could easily, the two lacerations above may not have ever impacted again when the bottom bruising occurred, right?
It's possible.
Okay. Mr. Guy focused you on life-threatening injuries, right?
Correct.
Did they suggest to you in your testimony that this has anything to do with life-threatening injuries?
I'm sorry, I didn't get that. What is that?
Did the state attorney's office, when they prepped you for your testimony here today, suggest to you that life-threatening injuries was an element of anything having to do with this case?
No?
Okay. You understand that the extent of injuries are not significant in this case, do you not?
I'm sorry, I didn't get that.
Okay. You understand that the extent of any injuries that Mr. Zimmerman incurred in this attack have nothing to do with the case itself, correct?
Object to that as calling for a legal conclusion.
Rephrase your question, please.
I will. Were you prepared for the examination to identify whether or not you could testify that there were life-threatening injuries or not?
No.
Okay. None of these injuries that you identified, as they turned out, were in fact life-threatening, were they?
Correct.
What about the next injury?
The what, sorry?
The next injury.
What is that?
The next injury he would have sustained.
I'm sorry, I didn't get that.
Could the injury that he didn't have to survive, could that have been life-threatening?
Object to that as calling for speculation.
Sustained.
I might just have a moment, Your Honor. Thank you, Mr. President.
Thank you. Any redirect?
Dr. Rao, who was it that appointed you chief medical examiner for District 4?
The governor.
And are you testifying here today because Ms. Corey wrote a letter on your behalf to the governor some years ago?
No.
Are you slanting your testimony anyway today because Ms. Corey wrote a letter on your behalf to the governor some years ago?
Absolutely not.
All right. You were shown some photographs by defense counsel. Were you provided with all of those photographs prior to trial on the disc that you referred to?
Yes.
In fact, I think you referred to 36 photographs of the defendant.
Yes.
Did that also include photographs of his hands?
Yes.
Would you expect someone who was undergoing a severe attack to try to defend themselves?
Object, Your Honor, outside of scope and also speculation.
Sustained on both grounds.
You were asked about a scenario where the defendant may have hit his head on the edge of concrete when you watched the defendant's walkthrough or recreation. Did he describe his head getting hit on the edge of concrete?
No.
Judge, thank you. That's all I have.
Thank you. May Dr. Rao be excused?
She may.
Yes, you
Thank you very much. You are excused. Call your next witness, please.
Mayor, the next witness is available, but could Councilman approach very briefly?
Yes. Have a 15-minute recess at this time. If you'll put your notepads face down on the chair and follow Deputy Jarvis back into the jury room. Please be seated. Court will be in recess for 15 minutes. Please be seated.
We're going to have the matters addressed before the jury's brought in. No need to be the bench, correct?
I don't know what it is you want to address.
Just an objection and request for a proffer of some testimony I think the state is about to present concerning some school records or school information or coursework taken by my client some year or two before this event. And just a general relevancy objection, I'd ask it be proffered, and then if there's any relevance whatsoever, that it be outweighed by its prejudice. And I just have concerns about putting in portions of a school book that he may have read in a course that he had 2 years ago, and that's my objection. So I would ask that it be proffered and its relevancy be shown.
Okay, response?
Yes, Your Honor. Actually, there are 4 different records, 4 different witnesses. The first is, generally speaking, a transcript of the defendant's coursework towards his degree in criminal justice at Seminole State College, and that shows that he took 149 hours, I believe, altogether towards that degree, including a number of classes over a number of years. Was on schedule to graduate, although hadn't yet. So that is record number 1. Record number 2 is one of the courses that he took, specifically taught by Professor Alexis Carter, and some of the homework assignments that he performed for that class. For the record, that course was titled Criminal Law and Procedure. It involved, as Professor Carter will indicate, discussions extensively of a number of Florida laws, including self-defense and the stand your ground law. Record number 3 is a application to be a police officer for Prince William County in Virginia, and simply the application and the fact that he was not accepted for that position. That is it. And then the 4th is a record of a Sanford Police Department application to ride along with police officers. Those are the 4 records. As I understand it, the objection is relevance as to each of them. Obviously, they all go to support a number of things, not the least of which is the state's underlying theory that this defendant had such an interest in law enforcement and law enforcement work that this is what he is, this is the position and the frame of mind that he is operating from at the time. In other words, this is what he wants to do. He wants to catch people. In fact, one of his homework assignments, he specifically mentions that. We believe that his chosen major, which actually has been mentioned in other evidence already, that he was seeking a criminal justice, is relevant to show that he has the education and the ability and the understanding, and has at least the background to be able to adequately discuss when he is confronted with police, both understand what it is that they might be trying to do and also what it is that he might say in order to address the situation in the light most favorable to him, legally speaking. I think as far as his knowledge of the law, that certainly would be relevant to his statements and his state of mind while making them, particularly as we just heard him tell Sean Hannity on national television that before this case he'd never heard of the stand your ground law. That would be directly contrary to one of his professors. And the other two records, the application to in fact be a police officer, as well as to ride along locally, I think would be relevant again for the same reasons. This is a ongoing pattern of behavior, and it shows that this defendant has had that interest for some considering time, and that this is very important to him, that he be able to act and potentially become like a police officer. And it is the state's position that one of our arguments in this case is that that's what he was actually trying to do at the time of the encounter for which he's on trial in this case.
Okay, response?
Well, the response, Your Honor, is that it simply isn't relevant. What they're trying to do is use a transcript, for number one, trying to use a transcript that he did, so he didn't even complete the degree, but to the extent that they're going to try and put before this jury that he went to community college seeking a legal studies degree is of no relevance to them. This event is supposed to have occurred within 7 or 8 minutes, exactly what happened that day. We have taken pains not to get into Trayvon Martin's school records and his past because we know that they carry a level of protection that they're supposed to protect. In this case, what they're trying to say is that because he went to college, because he went to high school, because he went to first grade, maybe even because he had a civics class, that is going to be able to get before this jury so they can focus not on evidence, not on hard and fast evidence that they have, but on some theory that he acted in a way after going through what he went through that night that he knew to say to the cops something that he said it while the evidence supports it. All I'm saying to you is that if it's relevant to an issue, a material issue, then let him show what that relevance is. The idea of just doing a witch hunt, if you can, or at least a fishing expedition, to try and argue to this jury at some point that he went to college and even that he wanted to drive along with a cop somehow is a negative thing, somehow suggests that it's bad that he wanted to go to college. I don't see any relevance, and if there is any minor relevance, rather than just a fishing expedition, it's certainly outweighed because
I don't understand when you say it's a fishing expedition from the exhibits that they're intending to introduce.
Okay, the fishing expedition part of it is what they're trying to say. They're trying to come up with some theory. They don't get to just say, Judge, it's our theory that he's a bad guy because he went to college, but in effect, that's what they're doing. Their theory is not supported, at least yet, and they're a week and a half into their case, hasn't been supported by hard, fast evidence suggesting the anger and the animosity they want to try and get.
I don't think what they're trying to introduce is, for that purpose, from what I heard Mr. Manti say, is for the Mr. Zimmerman's knowledge of criminal justice and techniques of investigation techniques, interview techniques. He did say on the interview that was played from the state's exhibit number 180, the interview with the Hannity show, when asked the question if he knew about stand your ground law, and he said no, he did not. So that's one of the things. It's the state's saying that it's not a fishing expedition, it's to show that the defendant had knowledge through course review as to police techniques for interviewing. I don't know what the course information is going to indicate, what was taught.
Well, the reason why I call it a fishing expedition is then, honestly, where does it end? And that's what I'm suggesting is a fishing expedition. Do now everyone who's gone to a 6th grade civics lesson?
That's not what they're seeking to introduce or trying to introduce courses that Mr. Zimmerman took in criminal justice or towards a criminology degree. It's not like they're trying to introduce that he took humanity classes or he took a 6th grade geography class. They're being specific. I haven't seen the exhibit. Presumably you have.
I'm not looking, sorry. I'm looking at it, I don't see anything that says stand your ground was the only thing he said he didn't have, but I'd have to look at it and see. 'cause
Well,
that's
there's
just-
4 exhibits up there if you want to take your time to look at them.
As I said, Professor Carter will describe in detail the stand your ground portion of that coursework. It's not referenced by name in the book. That's why he's here live. But that's sort of just an aside. I want to make sure that that point was clear if we're going to argue about it.
Okay.
We're gonna go, I guess, go back and forth a little bit.
Well, I would, again, I have not seen any of the proposed exhibits. I have no idea what you all are talking about in regards to each of them. If somebody would like to hand them to me, I'll review them.
Let me see the police In order, Your Honor, 209, which,
Second.
209, which is the coursework towards the degree, including a certificate from Professor Carter as to the specific class in question in which he awarded the defendant an A.
Well, these records are his college record that shows all other classes and what those grades are. I would agree that that's not relevant, and attached are grade change and academic record update form.
That is the record from Professor Carter awarding the grade for the particular class.
Okay, course title, criminal litigation,
Yes, Your Honor.
spring 2010. There's a diploma certificates application.
Which I believe shows the proposed graduation date of late 2012, 2013.
Is that the only class that, the criminal litigation, the others, there's a criminal investigation, I see.
Correct. The criminal investigation is the subject matter of the professor about which we had a discussion this morning, Professor Pleasance. And I have an update on that situation when we get to that point as well.
I don't know that all of these records would be relevant because they show other course of study, but as far as the criminal litigation and criminal investigation, they will be. So you need to redact these records to comply with that. What's the next exhibit?
Your Honor, the next exhibit is a composite of 210, and I don't know, this one is the course book material as well as the homework from the criminal litigation class. Mr. O'Meara at one point indicated that he wanted the entire course book entered, and so I have that available. I'm not sure whether that's still the desire. The other part is just the section relating to self-defense.
Now, is there a live witness who's going to testify as to these exhibits?
Yes, Your Honor, Professor Carter is here.
Do any of those have to be exclusively?
These all have been.
Okay.
Okay, I guess there's two parts of Exhibit 210. The first one are different homework assignments,
Yeah, it's from the course.
and a final project paper.
Yeah, continue to be heard on the projection that I was outlining before.
On this Exhibit 210, yes.
Actually, on all of them. I don't think the state can create evidence and then, for the sole purpose of impeaching it. They introduced Sean Hannity. They left in that portion about standing ground, and now they're trying to bring in additional evidence to try to impeach Mrs. Zimmerman on what they put into evidence. So I think, and I don't have the case law right here, but I'd be glad to present it to you, that they can't create evidence. They can't ask a question the way they did.
They didn't
and
ask
then-
the question.
Well, they presented the evidence.
Okay,
And they could easily have redacted that had they had the concern to. They left it in solely for the purposes of bringing in suggested impeachment to say that he did say something or know something when he didn't, when he said he didn't. So they can't create their mild problem by putting in evidence solely so they can impeach it. Your Honor, I think that that is unfair. It's inappropriate, and they shouldn't now be able to come in and impeachment. So that's sort of as an aside to what they're attempting to do.
wouldn't that be the same as declaring a witness as a hostile witness?
No, I think what they're doing is they can't open their own door, Your Honor. I think rather than impeaching as a hostile, what they cannot do is, as you sort of suggested last week in the trial, you can't open the door a little bit yourself so that you can push through it. And that's what they're attempting to do by leaving that in to an otherwise redacted statement, just as an attempt, a foothold, if you would, to get in evidence that now might suggest, not in the book, because the book says nothing about standing ground, but that some professor may come in, acknowledge that George Rosa was not even in class that day, and talked about standing ground. I presume that's what they're going to have him testify to. And they can't simply create their own impeachment evidence, which is what they're doing with that particular attempt.
Well, I'm going to have to give you time to look at some case law on that, because I don't know at this point in time that I agree with that.
If I may, the state's position would be, although it is impermissible to call any witness for the sole purpose of impeaching them, that is certainly not the reason that that exhibit was admitted, and I would point out that it was admitted upon stipulation of both parties.
Right, and the court even read the instruction to the jury that portions have been redacted. So that creates a whole nother issue.
And as to the school records themselves, even, I understand the court's ruling as to some of it, but even as to the other ones, again, I don't think it's appropriate for the state to focus this jury on evidence of my client.
But that's their case that they're trying to present to the jury. That's their theory of the case. And they're allowed to present evidence on their theory of the case, just as the defense is allowed to cross-examine their witness on their theory of their witnesses on your theory of the case.
My understanding is that at very least there needs to be some connection.
Okay.
That they can't just allege that he took a class in junior college a couple of years prior, and therefore then ask the jury to presume something without some direct evidence. And to date, there has been no direct evidence connecting any of that together.
But your cross-examination of the different witnesses regarding the incidents that occurred on that night gave an indication that the jury could infer that your client did not have any information about what self-defense means or is, or an understanding of the criminal justice system. So I think that that's before the jury based upon that. So if it's the theory of the state's case that Mr. Zimmerman had that information, or at least understood the process, I think they're entitled to bring that forward. If you would like a few moments to get some case law on that, I'll recess for about a half hour, and you have people there helping you. You can go ahead and try to find the case law.
As to the request for the proffer, then, can I at least request that the state proffer that they're going to be able to connect up? As an example, I mentioned a moment ago, if they're going to suggest that my client knew about standing ground, would they not need to at least present evidence from their witness that my client was present during some coursework that was given? If not, then it's pure supposition, and I don't think it would be then, the relevance is not bridged That's what I was talking about a moment ago, maybe not artfully, but if they can't connect the dots at all, they can't just allow this jury to sort of guess as to what it means. So if standing your ground is going to be an issue, and they now want to show he was there for standing your ground, shouldn't they at least show he was in class? And I asked for that proffer.
So I'm going to say one thing about that is we've now moved again, as so often has happened here, from the original objection to 4 different points removed from the original objection. If we're now asking for a proffer about whether or not the defendant was present, I think it misses the point. The point is he had access to this information in the book, he had access to the information from the class, and
I haven't seen the book.
and that makes it, you have the chapter in front of you, which is a portion of that exhibit.
The self-defense, chapter
Yes, Your
7
Honor.
is the portion
Yes, Your Honor.
that came from the book?
Yes, it did. And the relevance of all of this, again, taken together, is that the defendant did have this information or access to this information. Whether he wishes to claim that he wasn't there that day, or whether on cross-examination they wish to ask the professor whether or not he could guarantee he was there that day, that goes to the weight of the evidence, not whether or not it's admissible in the first place. It's relevant evidence. As far as the idea that it's more prejudicial than it is probative, it's odd to first say this is good things and then argue that it is so prejudicial that it is unfairly prejudicial to the point that any relevance it has is outweighed. Those two arguments are completely inconsistent with one another.
Let me try and make them consistent, because I
Okay,
don't
no,
want to
let me go ahead and do this, because we could go back and forth on this and all the time, and I'd rather give you the opportunity to go back and do a little bit of research. We'll be in recess for 30 minutes, and let me see what case law can be provided. The other 2 exhibits before we recess on this are,
One is an application to be a police officer.
and what is the date of that application?
That is, it was July 8th, 2009 was when that was resolved.
Okay, and the other one is an application to ride along. What is the date of that?
3/15/2010.
Okay, I will consider all of those. We'll be recessed for half an hour. Thank you.
maybe we could address some of the specific objections to the pieces of evidence, have you rule on those, then what's left, I might ask for some time for some case law.
Well, I was wondering if that is the case and we're going to spend the time doing this. Do you have any other witnesses that are not on this issue that are here available to testify? Okay.
Yes.
Why don't we do that? Why don't we go on to the next witness, and we can take this up after the court is over and take it up at 8:30 again in the morning. So we can do what we can after this unrelated witness testifies.
Yes, ma'am.
And then afford everybody that opportunity.
I'm amenable to that, Your Honor. I will point out, just so the court's aware, 2 of the witnesses are actually flown in from out of state, so we will have to make that arrangement, but I'll get that done and we'll
Okay,
get
well,
prepared to-
you know, this is the first time the court is hearing the argument about this.
Yes, Your
The
Honor.
parties have had these exhibits known to each side for I don't know how long. I didn't know until just now we were going to have that argument, and if parties are not prepared to continue on with the argument, I'm going to give them a little time to do so.
The state's prepared, Your Honor, but that's fine. We can wait.
Okay, let's go ahead and bring the next witness. Do you need somebody to get that witness?
Yeah, Judge, I think she's on the second floor. We're having her brought up right now.
Okay, thank you. With that in mind, is there anything else that we need to take up before we'll have the jury come in?
No, Your Honor.
Let me know.
I would ask the court's permission so I can inform the other witnesses that we won't need them till tomorrow and that
Yes.
they'll be spending an extra night.
Okay, thank you. Just when we know the witness is outside.
Judge, just for planning purposes, we believe those is very short, we believe, so, but I guess it's getting close to 5 o'clock anyway, so I think we're all right. I just want to
Okay.
alert the court.
Thank you.
With anyone going, we do have depositions set for this evening as well, starting at 5:30. So
Okay. Witnesses here, let's go ahead and bring the jury in. Please be seated. Mr. Guy, call your next witness.
Judge Kristen Benson, please.
Do you solemnly swear or affirm that your testimony in these proceedings will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
You may proceed.
Thank you, Your Honor. Good afternoon, ma'am. If you'd please tell the members of the jury your name.
Kristen Benson.
Ms. Benson, how are you employed?
I work as a latent print analyst for the Seminole County Sheriff's Office.
How long with the Seminole County Sheriff's Office?
I've been with the agency a total of 8 years,
And how long in the area of latent print examination?
just under 3 years.
Can you tell the members of the jury briefly what your duties are as a latent print examiner?
I examine items of evidence for the presence of latent prints. I also perform comparisons of latent prints to known standards, and I issue reports with my findings.
And if you could summarize, please, the training education that you've had to prepare you for your duties as a latent print examiner.
I have a Bachelor of Science degree in Business Management. I also successfully completed both the latent print technician and analyst training programs at the Seminole County Sheriff's Office. I also received approximately 300 hours of additional training from the Federal Bureau of Investigation, the Florida Division of the International Association for Identification, among other agencies as well.
Have you ever been tendered as an expert in the courts of the state of Florida in the areas of latent print identification and/or latent print comparison?
Yes,
How many times?
7.
Your Honor, at this time I would tender Ms. Benson as an expert in the field of latent print identification and fingerprint comparison.
She will be allowed to testify in that area.
Explain then, if you would, please, for the members of the jury, what is a latent print? What do you mean by that?
A latent print is the unintentional recording of your fingerprints or palm prints. When you touch a surface or an item, residue such as perspiration or body oils that may be present on your hands can then transfer the ridge detail that's found in your fingerprints onto a surface, leaving behind a latent print.
And what is meant by the expression a latent print of value?
A latent print of value means that there's a sufficient amount of information in that latent and the ridge detail in order to either identify a person or eliminate a person as being the source of that latent print.
Is a latent print of value then one that is suitable for comparison?
Yes.
How can a latent print not be of value or be of no value?
It may lack clarity. It may lack information in the ridge detail. It also may be heavily distorted.
If a person touches a surface, and I'll use my example, my thumb on that surface, is there any guarantee that I'll leave a latent print of value?
No.
Why not?
First of all, there has to be enough residue on the hands present to transfer onto the surface. Another reason might be is the surface of the item that you're touching or the object needs to be conducive to receiving a latent print. Generally, heavily textured or rough surfaces are less likely to receive a latent print than, say, a smooth surface would be.
Can latent prints be destroyed if they are deposited?
Yes.
How is that?
Excessive handling of a surface or the object that has suspected latent prints on it can wipe away, damage, or destroy latent prints. Also, environmental conditions such as rain or heavy humidity can damage or even destroy latent prints.
And in your field, what is meant by a latent print card?
A latent print card generally is a white card that's used to preserve latent print evidence on.
And how are those used in your work?
Generally, we receive latent print cards to examine for the presence of latent prints.
What is a known ink print?
A known inked print is an intentional recording of your fingerprints or palm prints for the purpose of identification.
And if you have a latent print of value and a known ink print, explain for the jury how you go about comparing those two to determine whether or not they were left by the same individual.
Once I've determined that there's a latent print of value, I'm then going to do a side-by-side comparison with the known inked print. I'm going to look for similarities and differences. I'm going to look for things that may be in agreement or not in agreement. And after a thorough examination and comparison is completed, I'm then going to determine that it either was identified with that known print or not identified with that print.
And did you have an opportunity to examine a latent print card in the case of the state of Florida versus George Zimmerman?
Yes, I did.
Your Honor, may I approach the witness?
Yes, ma'am.
Ms. Benson, let me show you states 183, already in evidence. Ask you, do you recognize that?
Yes, I do.
Is that a card that you examined in this case?
Yes.
And can you just kind of hold it up for the jury from where you are and just explain it to them, explain the latent card to them?
Okay, this is a latent lift card that was a area of interest was developed, and they placed a clear, or whoever lifted this print placed a clear piece of cellophane tape on top of the latent and then placed it onto the latent print card on the opposite side that you see here.
And did you examine that card to determine whether or not there were any latent prints of value?
Yes, I did.
Explain to the members of the jury how you went about that.
I used a handheld magnifier to examine the lift areas that were present on this latent lift card.
Did you find any latent prints of value on states 183?
No.
All right. Ms. Benson, did you have any further involvement in the case?
No.
All right. Thank you for your time.
Thank you.
Just very briefly. Good afternoon, ma'am.
Good afternoon.
How are you?
Good.
Do you even know from looking at that document you have in front of you where that print was lifted from?
There is a lift location that was filled out that says where it came from.
And what is that location?
The lift location says the slide of a firearm located within item TS-1.
Okay. And in effect, taken from a firearm, correct?
That's what's indicated on the lift card, yes.
Okay. And did you only get one latent print
Yeah.
to review?
Yes, I only received one latent card to review.
And you had mentioned that environmental effects can have a negative effect on latent prints, correct?
Yes, it can damage latent print.
And I think you mentioned that rain itself can?
It can.
Because what is left as part of the latent print or the makeup of the latent print are oils from the skin,
It can be, yes.
okay, and other debris, but it allows for the weight determination because the fingerprint can leave a minute amount of oily substance that actually is the print itself, right?
Yes.
Okay, and water can wash that away.
Yes.
So that fingerprints may have existed on an item that you would lift a latent from, and there be no latents whatsoever, correct?
That's correct.
Even though the gun's been handled by 1, 2, or 3 people.
That's correct.
Any other latent work or fingerprint work that you did have anything to do with the Zimmerman case?
No.
Great, thank you. No, nothing further.
Okay, thank you. Any redirect?
No, Your Honor.
Okay, thank you very much. May Ms. Benson be excused?
You may.
Thank you. You are excused. Council, approach for just a moment, please. ladies and gentlemen, we have some matters that we have to take care of outside your presence, and instead of having you sit back in the jury room, I'm going to go ahead and excuse you for the evening. During the recess overnight, you're not to read or listen to any radio, television, or newspaper reports about the case. You're not to discuss the case amongst yourselves or with anybody else. You're not to use any type of electronic device to get on the internet to do independent research about the case, people, places, things, or terminology. And you're not to read or create any emails, text messages, Twitters, tweets, blogs, or social networking pages about the case. Do I have your assurance that you'll abide by these instructions? Okay, thank you very much. Have a good evening. Put your notepads face down on the chair. Oh. Please be seated. Do council wish to continue the conversation at the bench? I don't know if you wanted to. Court is going to be in recess for the purposes of the attorneys until 8:30 in the morning for the jury till 9 a.m. Court is in recess.